dear participants from all over the world. We are happy to welcome you at this 36th session of the Global Digital Encounters. I must say that we had, unfortunately, to choose a topic that reflects the world as it is. That means wars and international tensions that are rising. In this very context, our family, the IP family, is affected by this situation, is affected in many ways. Of course, IPR owners in areas of direct conflict suffer very much, or may suffer very much, and also those who access IP products. At the same time, due to wars and international tensions, there is less unity in the world and less international harmonization. The new issues connected to open models may perhaps be slowed down, though they are priorities, or may, on the contrary, perhaps be solutions to overcome international tensions. And this is why, at this very moment, our team, my colleague, co-director, Professor Manuel de Santes, and my colleague, coordinator, Professor Javier Fernandez Laschetti, and myself, we decided that time had come to bring, unfortunately, war in our agenda. This is not an old issue in the intellectual property family. World War I, World War II, and other international tensions gave rise to articles, to many cases, and to doctrine, including doctrine studied by our distinguished colleagues. At the Global Digital Encounters, we want to thank our audience from all over the world, all our supporters for this pro bono activity, and also all our public that is with us in this very day. So, dear participants, enjoy the Global Digital Encounter. For the first part of the encounter, you will hear the replies of our speakers to questions made by our moderator. For the second part of the encounter, you will have the occasion to raise questions in our chat. I am very proud to know that there are many followers from Bocconi University, from my university, whom I greet on this very special occasion. So I think that we should leave the floor to the key speakers, Professor Peter Yu, who's marked academia by writing on this very important topic, to Professor Gabriele Cifrodelli from Glasgow University, and also to Dr. Andrea Valdomocchi, who also dedicates part of his life to academia. So the floor is to our coordinator, Javier, to mention also a few welcome words to all of you.
Thank you, Laurent, and welcome to all of you. The topic of today's session is quite interesting, and as Laurent has, Professor Laurent Manderio has mentioned, is the war affects many aspects of our lives, and also including the IP rights. I still remember the decisions Hack 1, Hack 2, and its influence in the exhaustion doctrine, and from that time, so it even can affect trademarks. And from that time to the current situation and regulations of the European Union and about the provision of services to states in conflict, and so on and so forth. So the topic is so interesting, and we are so fortunate to have today this moderator and speaker that will clarify us the many interesting aspects. So thank you again for being with us, and remember that you are a community, and we are very happy to have you, and hope that you will enjoy the session. Thank you very much.
So
Andrea,
thank you, everybody. I'm Andrea Valdomocchi, and I'm really honored to be here moderating this debate. The topic is fascinating. I would actually like to give the word immediately to Professor Yu, because he wrote a really enticing and long article, War and IP, with Brigham Young Law Review on the matter. Professor Yu, the floor is yours.
Thank you, Andrea. So let me start by extending my sympathy to those who have been affected by wars or other international conflicts. So when I was writing the article, I was surprised by how little research that is available since I would say a decade after the Second World War. This topic has not been picked up by others, but it's actually very interesting because there are a lot of different issues, all the way from the seizure of IP rights during the war to wartime extension of those rights, patent pool for military aircraft during the First World War, secrecy orders for patent applications, and then you also have some IP litigation involving submarine and torpedoes, right? So there are a lot of interesting topics, but very little research about what's going on there. And so what I'm going to start off is a few observations, which I think will help with this encounter. I'm also very excited to be just back here. So thankful to the organizers for having me here. The first one is that when we think about the intellectual property system, especially at the international level, we tend to focus on balance and coherence, but we don't really think about the resilience of that system. And after the COVID-19, we have seen that happening. We have the same system as we had before the pandemic, and that was actually started the same way when a lot of countries are very concerned about how war will create disruptions to our international intellectual property agreements. So if you go to the origin of the Paris Convention or Berne Convention, a key feature of the convention is that the union will stay the same regardless of the disruption in different parts of the world. And we have seen a lot of countries getting together after First World War and Second World War, continuing the development of the Paris Convention and Berne Convention without getting any major disruption, right? So I think that is actually quite interesting in terms of how resilient our international IP system has been. Talking about international IP, we cannot avoid thinking about, for example, the TRIPS agreement or some of the TRIPS Plus agreements that get into the investment area. So when you think about, for example, a TRIPS agreement, we do have the national security exception within Article 7.3. And that exception outlines obligations for those countries that are involved in the conflict, as well as those that are not, right? So for example, for a lot of conflicts, countries may be not involved in a conflict, but may have choose to take sanctions against some of the belligerent parties. And I think Article 7.3 will provide some options for those countries to consider within the TRIPS framework. The same thing goes to some of the investment agreements. So for investment agreements, there are both exceptions with respect to the situations affected by wars and crises. There are also the mechanism that's called investor-state dispute settlement that will allow countries to address some of those issues affected by war. I think you raise some difficult question with respect to expectations during wartime and how you actually proceed with respect to settling dispute with investors and the host states. But those are interesting questions that we need to ask both during the war as well as after. Another thing that is actually quite surprising to me when I was helping Ukraine and trying to address some of those issues is that we tend to think about war as a one-off event. But when you think about how to make arrangements with respect to intellectual property, we need to be conscious of the fact that we might have the tension between wartime as well as after the war in the rebuilding effort. And so how are we going to adjust a lot of those issues? And I think that would be quite important. So a good example would be during the war, we might need to have more compulsory licensing to help provide medicines, to provide access to things that are protected by IP rights. And yet, the more we push for compulsory licensing, the less likely you will get help from other countries that have a strong protection for intellectual property rights. And so you don't want to alienate the potential allies, right? So those are difficult questions. I think for Ukraine, a big question is, do they want to keep intellectual property at a very high level so that it'll be easy for them to join the European Union after the war, or do they want to actually provide more special arrangements or compulsory licensing so that they can address what they need during wartime, right? Those are, I think, very difficult questions for those people who are involved. I think another thing that we can explore is with respect to technology. I know we'll have a little bit more of that in the discussion. I think whenever we think about technology, there's always difficult question about the technology being the double-edged sword. It can actually benefit humanity, but it can also hurt humanity, and especially when we talk about wartime, international conflicts. I think those issues will come into play. And the final thing I will end on is that war has different definitions, right? You can go all the way from military wars all the way to trade wars, and then you can also get into like war on counterterrorism, war on poverty, war on piracy, right? So I think we need to be very conscious of the fact that sometimes the rhetoric with respect to war will be used, even though we typically would not consider it at the same extent as what we are seeing in the world at the moment, right? So there are a lot of very interesting issues with respect to that topic. Let me pass it back to you, Andrea.
Thank you, Professor Yu. I think you put on very interesting themes. I think the first question could unite what you said at the beginning, what you said at the end. So there are indeed several definitions of war, and as you noticed, there was a development in this theme after the First and Second World War, which were the epitome of conventional war among states. But now we see a lot of less conventional war. We see low-intensity conflicts in many areas of the world. We see trade wars, sometimes the use of cyber attacks that is looming among above us, and there are many non-statal actors. There are terrorist groups, there are huge corporations, and there are a lot of international organizations that not only were in place at the time. So how, and also, as you said, we have the TRIPS, an agreement that encompasses most of the statal actors in the world. So how do you think that this will impact the IP system coherence and its stability?
I think increasingly we have difficulty think about coherence, in part because we have too many different international agreements going in different directions, right? So I don't think it's necessarily a result of what's going on with either international conflicts or more specifically, I think it's just the state of the international IP landscape that we are dealing with at the moment. I think the interesting question would be that whether we will be able to find solutions both at the international level as well as the regional level, and that depends on a lot of the treaties we have been in place, but it also depends on a lot of different effort that are put together by different people. I think increasingly we need to think about the fact that the national intellectual system can be affected by many different things and not just the international arrangements. And so when we are trying to make adjustment, sometimes if it doesn't work at the international level, we might also consider for other options, whether within our traditional intellectual property system or whether it's outside through different arrangements, whether it's through business or whether it's through technology.
Thank you. Professor Cifordelli, you want to add your opinion here?
Yeah, thank you very much. The doctor is fine, by the way, it's fine. I'm not professor yet, especially not at the level of Professor Yu. No, I gotta say, I found fascinating all the aspects that Professor Yu covered, especially for my kind of more field, which is the international tensions during pandemic situation, during emergency situations. So what's the way to go? Because we've seen during COVID, the pandemic hit, and it hit quite hard, but unfortunately only the developed countries got first access to massive vaccination programs. So meanwhile, developing countries were kind of excluded by that. And unfortunately, the instrument, even the TRIPS, even the compulsory licensing at Article 31 and 31 bis in the TRIPS agreement weren't that effective. And probably, as Professor Yu was mentioning, it's because we have too much. We have too many international instruments and overlapping instruments that probably are not harmonized, and they are fragmented in a way that they contradict one another. For example, and this is something that many scholars argue, one of the reasons why the TRIPS agreement is not working that well anymore is because there are many bilateral agreements, especially by the US with developing countries, least developed countries, where essentially we see an override of the provision in the TRIPS agreement, which can be problematic in this sense because they basically supersede the provisions that we find in the TRIPS agreement. So I'm talking, I know that it's weird talking about that from Europe, where probably we have the most fragmented situation, especially when it comes to IP. But probably, I'm not saying fragmentation is a bad thing, because it helps, cultural, national traditions and cultures to grow up stronger, I would say. But on the other side, we have to consider that during an emergency situation, like a pandemic, like a war, probably a more nuanced harmonization through international agreements, through international dispute resolution mechanisms could work better in this sense, because we are all in this together. In the pandemic, we were all in this together. If we didn't if the rest of the population, of the world population, wasn't vaccinated, we couldn't get rid of all the variants and different strains that the COVID-19 virus produced. So we want to be able to face the situations kind of together in this sense. It's complicated, definitely, but harmonization probably is key in this sense.
Yeah, I agree with you, and the point raised is really interesting. The fragmentation of treaties and the overlapping surely stays in the way of a better functioning of the system, and it's indeed a problem that will have to be resolved somehow. What you said about Dr. Cifrodelli, what you said about the pandemics and what Professor Yu was saying before brings me to my attention the fact that not only we have a lot of treaties that overlaps, but also many of them, and especially the TRIPS agreement, allows for state to use exceptions in case of the national emergencies or their national interest come on the line. This use clearly it's important for states, but could get in a sort of tension with the system. So I would ask you again to Professor Yu, and then we can go to Gabriele, to Dr. Cifrodelli. Do you think that there has been too much use of national interest exceptions? Do you think that this could disrupt the system in the long run?
So before I get to that, this is actually a very good question. Let me get to some of the things that Gabriele talks about. I think it's very interesting. So when you go back to COVID, right, we keep on talking about combating virus. We need to fight the pandemic, right? So there's a lot of discussion that actually goes in the direction we are talking about, right? Whether you think about wars, you think about international conflicts. And I think one of the challenges with respect to all the TRIPS Plus agreements that Gabriele was talking about is that when we created the WTO, we expect that we can use the mandatory dispute settlement process to address a lot of those issues, so that we will be able to harmonize a lot of those disagreements, I think some of the disagreements during the TRIPS negotiation get pushed with the expectation that we can use the dispute settlement process to address some of those issues. I think increasingly it's difficult to do that. One is that different agreements have different dispute settlement process. We also have some issues with respect to WTO, especially with respect to the appellate body, right? So that becomes very complicated in terms of how we can actually move forward. I think with respect to fragmentation, when we have international crisis, I think the immediate thought is that we need to have more international action. We need to work together. What we have seen is actually the opposite, right? Because all the governments need to be very focused on protecting their own individual citizens, and they will not be able to cooperate, even though, right, we know very well that no one is safe until everyone is safe, as we always say during COVID, right? And we have what people usually describe as vaccine nationalism. And I fear that this sort of nationalism will continue in other areas beyond the pandemic. And in terms of international crisis, it will not be surprising. And what is actually quite interesting for me during the pandemic is that a lot of the things are playing out as if the same way as we have seen in some of the movies, right? So I think that actually can be, I think, can be a kind of it can be a wake-up call for a lot of us in terms of how we actually go forward with some of those issues. But going back to your question, I actually don't think a lot of countries have been overusing national security exceptions successfully, right? They have been making arguments, but we have seen in some of the cases that before WTO, we have seen in other contexts that national security exception has been interpreted rather narrowly. With the hope that countries will be able to continue to rely on the international norms set up by the different instruments, right? So to the extent that we can no longer rely on a strong dispute settlement process, I'll probably be more concerned because we don't really have basically the world police or super government to be able to stop people from pushing for position that would be in line with how they protect the essential security interest. But at the moment, just based on what we have seen from different decisions, for example, with the WTO, we haven't been going in that direction.
Thank you. I will leave the word to Professor Ciufrodelli to answer, even though we have raised again several interesting questions that I would like to go back after your answer, Dr. Ciufrodelli.
Yes. No, I can just echo everything, Professor, you already said. I think we need, as I said before, more harmonization when it comes to these international instruments, and especially we need to use these international instruments that are out there. But also, if we look at the compulsory licensing, if we make a comparison between compulsory licensing and the national exceptions, so the two extreme points of view, also the compulsory licensing on a more international level hasn't been implemented, even when the WTO finally decided to go even to be bolder in this sense and say, okay, we need a compulsory licensing that allows domestic manufacturing, exportation of medicines to countries that cannot provide domestic manufacturing. Even in that point, we didn't use that instrument in that way. Why? Because the process has been declared too cumbersome. We have the example of Canada and Rwanda, where Canada was supposed to help Rwanda in having some antiretroviral drugs, but they never succeeded in this way because Apotex, the generist company that had to provide these medicines to Rwanda, said that the process was really cumbersome because there were so many conditions, so many aspects to take into account. I understand that international law, and probably people that do international law, scholars in international law, know that definitely way more than me. It's always a matter of compromise between different aspects. But I think we need to be bolder in this sense, especially when there is an emergency situation in this regard. Look at the WTO waiver for COVID-19 related technology for vaccines. They did that in June 2022. We had this waiver finally decided for, but very limited one, only for COVID-19 vaccines technology, and also quite late compared to the frame of the vaccination timing that we had before kind of this decision. So I guess it's a matter of coordination, harmonization, and definitely kind of phasing these issues together. Again, it seems utopistic in a way, but I think we should consider that also from a policy perspective.
Thank you. That has been a really interesting intervention. And as Professor, you noticed before, there was a saying that nobody is safe until everyone is safe. And at the same time, there was a lack of coordination. It seems to me a bit of a prisoner dilemma, which, as it is known by game theory, it's really difficult to solve with the contrasting interest. At the same time, sometimes the world, it can be the pandemics, the virus, the war, it moves really fast. And so there is the need to act fast. And before going to the next question, I would ask you a really brief intervention on this. Do you think it could be time to a revision of the TRIPS agreement? Do you think this a revision of treaty could be a solution in this sense or not? I think that Professor, you can.
Yeah. So I think the difficulty that both you and Gabriel was getting to is that in terms of when we have international crisis, right, we need international law to work. But during international crisis, most likely international law will not work, right? So how are we going to make preparation for what's going forward? And I think as we have seen during COVID-19, I think when we think about trying to get a waiver that has been coming from a proposal from both India and South Africa, I think one of it is obviously a debate as to whether IP is actually the cause of the problem. I think the other one that I think a lot of people overlook is that we need to keep in mind that the waiver has to be negotiated within the confines of the WTO negotiation process, right? So that that becomes quite complicated. And one argument that I've made even during the pandemic is that whatever we are going to negotiate will not be for this pandemic, will be for the next pandemic, right? We have seen what happened with Article 31 bis. It was initially discussed as in the context of paragraph 6 of the Doha Declaration, and then we have the ministerial decision in 2005, and it was not ratified until more than a decade later, right? So if we're going to get something within the WTO, and that goes to your question about the TRIPS agreement, right? It's not just about TRIPS agreement, it's also about WTO context. I think the institutional arrangements doesn't allow a quick waiver to occur, right? So if we continue with that type of system, I think we do need to start thinking about how to put together a system that can address that type of issue in the future, right? So I think a lot of medical experts have already said that we're going to see the pandemic in the next 10 or 20 years again, right? We've seen SARS, we've seen Zika, we have seen the H1N5, H1N1, and then we now have the COVID-19, right? So we're going to see another major pandemic in 10 years, right? If we are counting on what Gabriel was suggesting in terms of making exceptions to the international arrangements, we need to start negotiating now, right? Because once we get to international crisis, international law is not going to work as we expect, right? So we may as well actually try to address this in peacetime.
Thank you. Dr. Cipodelli?
Yeah, I really like this idea of acting in a preventive way. Otherwise, we cannot make it. Look at what is up. For example, now there is in discussion, negotiations are proceeding for the pandemic treaty at the level of the WHO. I didn't look into that much, I gotta be honest, but specifically. But again, that's an example where this, I think, if we kind of start thinking, okay, we need a new treaty here, and we need a new treaty there, and another one. I think that could bring even more fragmentation. When I refer to, and also when Professor Yu was referring, and Andrea as well, we were all referring to international activism in this sense. It's maybe about modifying and updating what we already have, because there are some foundational structures that are kind of solid in our agreements, but we need to refine all the specificities of these provisions that probably governments around the world don't even know exactly about. And so instead of adding material and adding kind of the pandemic treaty and then the accord on releasing to the public domain certain aspects of certain subject matter of patentability that has been in discussion, probably we don't need that. We need more of what we already have in a better way, because I don't think that would only add fragmentation in something that is already fragmented.
I agree with you both in this sense. One thing that it is very often heard is that law follows society and tries to regulate it. The European Union does that a lot, but sometimes without exceeding, law should come before and set in place the pieces in order to prevent problems. And this is probably one of the case. It was a moment ago I heard about issues on patentability and secrecy, and in fact, and I think that later we could go back to the settlement resolution dispute. I think it could be interesting to ask ourselves in this fragmented landscape with many problems and many treaties and so on. Could, and also in the context of this international tension that are rising, as we have seen, could this cause a loss of trust from private actors into IP system and maybe push them to patent less, which is a bargain between state and private in order to get the publication patent less and keep more innovation secret in order to avoid these problems of IP system?
Should I?
Yeah, I think you can continue, and then Professor Yu could go again and give his informed opinion.
This is a very, very good point that you are making. I think, yeah, there is this risk on the horizon that we make the patent system too complicated, too difficult, that companies would just say, okay, I'm going to use trade secrets way more. That we don't want that, because we know trade secret is a very strong IP protection, which sometimes is necessary. But what we need right now, and that's kind of my 2 cents on the topic, it's more collaboration and more open innovation and technology transfer and less secrecy. And again, some people might disagree. I recently wrote an article on the topic that talked about the technology transfer, especially for fundamental technologies related to life-saving treatments like vaccines, therapeutic and diagnostics in COVID-19. I think we need more of that, and so more secrecy wouldn't help. How do you make that? I think, first of all, how do we obtain that? I don't have the definitive answer, but what I can say is that we need to understand, and companies need to understand, that having a governance that resembles the governing knowledge commons, so a governance that is open, that is based on openness in this sense, on open innovation, doesn't mean that there aren't spaces of property at all, that we all release everything in the public domain and then the original IP holder loses everything in this regard. I think it's a third way. It's a third way that sits between the complete openness that could create problems of their own, like the tragedy of the commons, as Ardin argued. But on the other side, the complete privatization secrecy that doesn't really help neither the IP holder nor definitely the public at large in this sense. And there are incentives there. There are incentives on a governance that is led by commons, not even from a governmental point of view, not even with the government, with involving the government in that, but just community members that work together, researchers, scientists that work together in this scenario to create something that is more commonized than privatized in this sense. I'm happy to come back to the topic, but after definitely after hearing from Professor Yu in this.
Thank you, Dr. Cifodelli. I would say here that one thing you said just a second before leaving the word, because I would really like to hear Professor Yu's comment also on what you said. So now it is a sort of a double question, what I asked before, and this issue of the global of the commons. I think also from a practitioner, which I am, a point of view, very often private actors tend to think that there is either secrecy or the patent, this kind of protection, and except for in some areas like certain softwares, think of certain like Ubuntu, the commons is not a concept very new. So, Professor Yu, you have the floor for this rather interesting topic.
Sure. So I agree with what Gabriel said, and I think it's important to keep in mind that the reason why we actually set up the patent system is to make the knowledge available in exchange for the protection for the invention, right? So I think it's very important to do that. I think, Andrea, you mentioned that law follows society, right? But we need to remember that society also gets captured, right? So a lot of the provisions we now see gets into different issues relating to how open the system will be, right? So as you mentioned early on about the secrecy orders, I think whenever we get into emergency situation, we get into wars, the way we think about how open the system will be is somewhat different, right? So I think that becomes quite complicated. I think there are still a lot of interesting provisions about secrecy orders in different patent laws in different countries, right? So for those of you who are listening and you are very interested, go and check that out. You'll be surprised by what you find. The other thing is what Gabriel was talking about in terms of whether we can actually make things more open. I think it's the difficulty with respect to what we have seen during the pandemic, as well as in the patent system in general, is that a lot of times it's not only just what is patented, right? We also need to have textile knowledge in order to make the vaccines, in order to do that. And sometimes commentators actually make the distinction between textile knowledge and codified knowledge, right? I think increasingly we need to think about this as a spectrum, right? We need to actually have a better way to treat different type of knowledge, whether it's codified, semi-codified, textile, right? So people talk about, for example, there's latent knowledge, there are different types of knowledge that is somewhere in between. I think that will be useful for us to actually think about how secret should we keep some of the knowledge. The other thing that actually comes up in the past few years, especially, but that's been going on for a decade now, is about increased protection for data, right? So it's no longer just about knowledge, right? When you think about big data analytics, you think about AI, machine learning, I think there's increasing push to actually have strong protection of data. And so we are having the level of protection for IP is getting more and more granular, right? So I think that becomes quite challenging in the opposite direction of Gabriel is hoping that we can achieve. One thing that is worth thinking a little bit about in terms of open innovation is that one is not mutually exclusive, right? You can have open innovation, you can have the current system, whatever would work for you, you can actually go in that direction. I think the difficulty is there's a tendency for those who are on one side or the other believe that if our system is working, your system can work, right? So I think it's important to actually emphasize the fact that we can actually have it both at the same time. I think the default issue, though, is that how can you get those people in one camp to migrate over to the other one, right? So we have seen during the pandemic, there's the open COVID pledge, right? But at the same time, we were not able to get the vaccine manufacturers to join the pledge, right? So that raises question as to how likely we can actually get other people to actually embrace the system, and also would it be too late by the time we actually have any emergency that we need to actually get them to enroll quickly? I think CTAP is another good example where they actually try to do the technology pool, and they also have limited success in trying to do that. But then the question we ask is that maybe it's not the model, maybe it's the institutional constraints, maybe it's just the timing, right? So one thing that sometimes we forget is that had the waiver been negotiated and much earlier in terms of a textual negotiation, the situation will be very different. Because by the time when you get to MC12, the ministerial conference, other countries are already starting to recover, right? So it's no longer just about geopolitics, it's also about the timing, right? So when we talk about open innovation model, right, I think big question is that, well, maybe we should start having discussion earlier so that we don't need to actually deal with that tough situation and try to actually come up with a new model to get people to have buy-in.
Thank you, Professor Yu. I agree with you that the issue of how to compel actors to join a system, in particular open system, it's quite difficult, as it is difficult to make this idea that knowledge can be classified on a spectrum. You just don't have big different fields that are opposite to each other, as it is probably still a common idea. On the issue, there is actually a question that has been made by the public, so I would like to read it to you. And I think that Peter can go, Professor Yu can go on talking about that, and then we can switch. So the question is the following. We see trade secret up in agenda of governments. Does the international tension boost this agenda rather than commons and openness agenda? So how's the relation between the two things?
So let me get the question better. So it's the question about whether the international system boosts the open innovation. Can you repeat the question? So
yes, I think that the question is about the government's agenda and how this growing international tension relates to that. So do the rising international tension tend to boost an agenda focused on trade secret, or they tend to go in the direction of governmental, so state agendas that aims more at the development of commons and openness? So what do you think that the statal actor will try to go and push?
thank you. So I was actually interrupted by some statics. So I think it depends on, it can actually go in both directions, right? So when we have international crisis, we need to get more international cooperation, and you'll be surprised by how many countries are willing to throw away their traditional positions and work together, right, to address a common international problem, right? So that is a time for cooperation. There's a time for them to realize that, well, we need to figure out how to actually get the job done before we actually start exploring how to divide the pie or how to address a lot of other issues, right? So I think in terms of the collaboration, in terms of open innovation, I think that's actually a very good time for them to do that. There are still rhetoric in the background, but I think if we are talking about, for example, the first year of the pandemic, I think it's very unlikely that a lot of countries will say, no, we're not going to cooperate, right? Because we all want to actually achieve the same goal. I think, as I mentioned earlier on, we tend to forget that toward the tail end of the negotiation of the waiver, we are in very different world where some countries have been opening up, other countries still are trying to get more access to the vaccine. That becomes complicated, right? So when the international problem goes away, it becomes more difficult for them to actually collaborate. But the other thing which I think a lot of us who are researchers can actually help on is that we don't really have a lot of models that are easy for negotiators to quickly adopt, right? We do have a lot of models that we have been thinking, exploring, and trying to move the intellectual property system or innovation system in a different direction. But I think it's still, we haven't had been able to get a lot of the policymakers to actually embrace what they have. Sometimes it's just because they tend to get a lot of lobbying, for example, from the industry. But sometimes actually that a lot of our proposals are just very theoretical and academic, right? And we actually need somebody to actually figure out how to translate this into a model that is workable, right? So, and I think there are a number of NGOs that have been actually very effectively trying to implement some of those models, and I think that would be a good start. But at the same time, I think if we are trying to figure out how to actually deal with, for example, the ongoing international tensions, I do think that we need to have something that's easier for policymakers, as well as those people who they're working closely with, whether as negotiators or whether the staff, to actually be able to pick up quickly.
Thank you. Dr. Cifodelli?
Just to finish on that, I agree with all has been said. If I can add also an element, it depends also on what government and country we're talking about, because and this relates to the argument that Anu Bradford makes in her recent book Digital Empires. I don't think the three models, the US model, the China one, and the European Union one are so separated. There are connections, there are intricacies there, and relations there. But of course, we are talking about three models that whose rationale is a bit different, depending on which one we are talking about. We have the US one that is more techno-libertarian and more like, okay, let the companies regulate themselves, and that's pretty much it. And that would mean either a more privatization of some companies, especially the big ones, the big techs, or maybe, especially in the startup world, something towards more openness and more open innovation on the other side. Then we have the European Union that says, no, we regulate with the AI Act, and then before with the GDPR, we give the rules because we believe in a rights-driven model where essentially, and again, in that case, the legislator themselves can point, depending on the rights at stake of the individual, can point to more privatization or more openness. And then the Chinese one, that once again, I see it as definitely state-driven, but again, probably also to make things more open, not just to privatize everything and make the government have all the control, but probably there are some margins of expansions in the openness openness area in this regard. So it really depends what are the interests at stake, as Professor Yu said, and the timing, of course. During a pandemic there might be a different argument than during normal times.
Thank you. I think that this is developing a point that we started to address before, but it's again interesting, the point of the innovation is relying a lot on data and the development of artificial intelligence. And Dr. Cifodelli said that we have a different model competing against each other. We have also models that could be inspired by different goals, because we could say that one goal is just the technological innovation, and we could say that a goal is the protection of the consumer or of the singular person, and tweaking the model depends on what the legislator would like to achieve, I would say. So I was thinking that at this point, Professor Yu could give a glimpse of his opinion on comparison between this system. What do you think about that, and how do they relate to the future society, the future technologies we are going to have?
So Gabriel brought up Professor Bradford's new book, right? So it's actually very interesting to look at how Anu has moved from her first book on Brussels effect, right, to the new book, right, that talks about Brussels effect, Washington effect, and Beijing effect, if you put it in the same terms, right? So I think when you think about the changes we are now seeing, I think that the different system can actually affect the different models we have seen. And I think one thing that would be quite interesting is the role of government in the innovation system, right? That's actually the topic of the WIPO report that was published shortly after the pandemic, right? So I think when you think about, for example, state-driven innovation, I think there are a lot of criticism with respect to that type of approach, especially when state are trying to go into the market as a market actor, right? But at the same time, to the extent that you want to have a different innovation system, that is also can be quite effective. There's a reason why governments throughout the world was actively involved in trying to combat the pandemic, right? We have seen government funding coming from not just the US, EU, China, but also other parts of the world where they actually actively involved, right? So I think that's there's a big question for us is that, well, what's the role of government, right, in the innovation system? Do we want to have the traditional model where we actually rely on private sector within the IP system, or do we want them to actually play a bigger role? And then there's also the question is, well, what if they play a bigger role and we do not like that role, right? So how are we going to actually address that type of consequences, right? I think those issues will come up. The other thing, since the previous exchange get into something about, for example, AI, I think we need to be very conscious of the fact that it's getting more and more expensive to develop AI for a lot of countries, right? So if you look at the foundation models that are developed by OpenAI and our developers, we are going from all the way to over 100 million and toward over $1 billion, right? So my biggest fear these days is actually that increasingly a lot of countries will be left out, right? They will not be able to come up with the type of AI models that they need. They will not be able to have the expertise so that they can actually compete effectively. Obviously, a lot of those technological developments may change. There might be cheaper way to actually do things. There has been some discussion about the fact that we should not just look at large language models. We should also think about small language models. We need to think about other ways to do things, right? But at the same time, I think we will have tensions going in a different direction, right? To some extent, that might be similar to what we have seen with respect to a digital divide concerning the internet, right? So I think those are the issues that actually will become quite complicated when we think about technological development. Because yes, we do have different dominant models that compete with each other, but ultimately the competition doesn't get to the part that get left out, right? So that is something we should pay attention to as well.
Gabriele, Dr. Ciavarelli, you want to add?
Yeah, I just add something. Definitely, I totally agree with what has been said, but we have to consider also what we are facing right now, especially in terms of Gen AI and what kind of companies we are facing here. Because some people might argue that we are facing a new wave of platforms, the platforms that wholly host content. Here, instead, we are in a domain of companies that, from the name also of the technology that they implement, create content themselves on their own. For example, why am I bringing this up? Because if we let them regulate themselves, they might adopt, as I can I have proof on that because I conducted a study on some terms and conditions of a few Gen AI companies that at first were treating themselves like platforms without any reference to their training systems, no, how they train their AI and what the input is, but just by referring to classic boilerplate clauses around copyright ownership, always upon the user, and so forth and so forth. But we need to consider that these are different companies that probably require, as also Professor Yu was saying, a different kind of regulation in this sense. Again, because if we leave them regulating themselves, probably they might go in a road that is not relevant from a legal point of view. And this, if I can say, Dr. Mocchi, also relates to the question that I saw here, a super interesting question that I can see here in the chat about the text and data.
Yes, absolutely.
Yeah.
Let me read for both of us and for the public, and because we don't have unfortunately much time more, so has been asked the following. So in the light of AI and the need of vast processing of data, there are some regions of the world that are introducing exceptions, enabling the processing of copyrighted and protected material, like the data mining exception in the UAE. So this might entail that companies pick certain friendly jurisdictions to train the AI model, and this clearly is a problem. In IP, which is linked by territoriality principle. So, do you both see that there is the need to put this type of mechanism in the agenda, so that there is a global standard for these practices, or there are any initiatives in this sense? I think that you might continue, and then, Professor, you could close on this.
Yeah, very interesting question. Thanks for that. Because while I was reading it, I was like, yeah, this is a good point. A global standard to allow the training of AI in a kind of an open and easy way, instead of being considered as copyright infringement, for example, like it's happening already around the world. We have already some litigations rising up about like some artists, some people from the creative industries going against these big tech or these Gen AI companies that train AI. And probably, yeah, at one point we need to consider a global standard in this regard. And this is where I think the EU and the US, I don't know about other jurisdictions, these are the jurisdictions that I know, are very different and very difficult to harmonize, because it would go in the roots of their copyright conception, which for the US is more business related. That's why it's copyright. For the EU instead is more author's right. So the focus on the on the creator of art and all of that. So that's why adopting a global standard probably at the end is the solution, but it will be super difficult, because as you in the question there was already a mention of it. In the EU we are trying to adopt a little bit more and see how this TDM exception works also for AI training. In the US they believe, most of the scholars, they believe in a fair use or fair training that find application for Gen AI content, and training of AI. So it's because it goes in the roots of the respective copyright systems. It's a very deep question at the very end, so very difficult to harmonize in this regard.
Yeah, I agree with you. And as we have seen, the harmonizing efforts are difficult, and they can create overlapping of treaties. They can create fragmentation. So it's a difficult terrain to move. Professor Yu, you want to add on this matter?
Yes. So one project that I've been currently working on is whether we can come with an international treaty to address issues at the intersection of AI and IP. But the question actually gets to the article I just posted onto SSRN about how we are having an emerging equilibrium on corporate exceptions for AI training. So the article is written together with Matt Sack from Emory. And what we're arguing is that we do not have any international consensus, right? So US, Israel have fair use, and Japan, UK, EU, and Singapore have text and data mining exception, and China is still trying to introduce implementing legislation, right? So we do not have any international consensus. But there seems to be some emerging equilibrium in terms of how they're approaching AI training, right? So they might not necessarily have the same way of drafting the statute. They might not have the same approach where it's open-ended, where it's closed. But at the same time, you end up with the same destination, right? So that was the article. But but when we think about that equilibrium, it can be upset by different things that are emerging, right? One will be litigation, they're ongoing, which Gabriela is already mentioned. And in the US, we got more than 24 lawsuits that are going on at the moment against AI developers. There are some licensing deals that's going on that will affect how we actually interpret the phase factors within the US, because some of the licensing deals goes to tens or hundreds of millions of dollars, right? So that becomes a very big issue in terms of whether this will be an impact on the corporate holder. And there are also a lot of regulation and legislation that's going on. And I think in the EU, as Gabriel mentioned, there's the AI Act, right? So I think one interesting question with respect to AI Act is Recital 106, right? Whether the regulation will have extraterritorial effect. I think the way I read the regulation, obviously, you guys will have a better take on the issue in Europe, but the way I read it is that there are two major issues, right? One is about enforcement. The other is about choice of law, right? So I think those will actually affect how big the extraterritorial effect we have in the AI context, especially with respect to AI Act. And the final thing I would add is that we tend to look at the need of regulation to deal with issues like, for example, job displacement, right? So we need to make sure that we have to slow down AI development because a lot of the output coming from generative AI technology is going to replace some of the human workers, especially in the entertainment industry, journalism, in other places, right? But increasingly, a lot of companies already have enough data where they can start training without using the cooperative works from other people, right? So I think we need to be thinking about whether that type of approach would actually make those companies that already have a lot of data, right? So Gabriel mentioned the platforms, right? That's a very good example. They already have the data, they train it, and they are not infringing on the copyright, but then they will become even more powerful because a lot of the competitors will be constrained by all this new regulation about how they can actually come up with training data, right? So to the extent that we care about the competition, to the extent that we care about market power, right? That can actually backfire.
Thank you, Professor Yu. It's been really interesting. Unfortunately, we are already well above our allowed time. So I will thank you both of us for wrapping it up and pointing out all this interesting issue. I will give the word to Manolo De Santis for our final closure. Thank you for being here. Thank you for both of us.
Thanks very much, Andrea. Having you today as a moderator of this 36 encounter has been a pleasure. Thank you. So dear Peter and dear Gabriel, we are also very grateful to you. Be very, very welcome, you three, to the Encounters family. You know, the Encounters family is already composed by 100, or more than 100, of remarkable scholars and professionals, and now you are part of our family. Peter was already. I have the feeling, after having listened to you so attentively and so carefully, that we could have spent many hours reflecting on the very issues you have brought on the table, related directly and indirectly to the consequences of the war for intellectual property. But believe me, you will be surprised later on when recognizing in the report the many questions you have brought on the table just in 1 hour is amazing. Yeah, just let me recall just some of those who just touched my attention. You have highlighted that it is of utmost relevance today, the harmonization between conventions. Yeah, the network of conventions is so dense that knowing what is the text applicable and solve the potential conflict between conventions is of the great relevance today. Yeah. Another issue, for instance, if I recall, is the urgency of acting now to be ready for the future. Yeah. It is now when we need to start negotiation treaties, providing answers to future conflicts. Yeah. Waiting for the conflicts arising in order to provide an answer is certainly too late. And this has shocked me also. Yeah. Of course, you also have mentioned the role of the government in the innovation system, the fact that IP use becomes more and more expensive for many countries, the famous Brussels effects, a topic to which we will devote an encounter pretty soon. Yeah. Whether we need more open innovation and less secrecy or not, what an issue. Yeah. Or how to arrive to global standards on specific matters like training and artificial intelligence. So, as always, you know, the purpose of the exercise was not at all to exhaust the matter. So be sure that we will have every single item you have brought in the table. We will have it in mind for the next encounters. And there we will have the opportunity to dig on these specific issues. So many thanks also to all those who have attended the encounter today. We are very grateful to your fidelity towards the encounters. We appreciate whatever advice you can provide to us. And also thanks to the hundreds and hundreds of persons who will listen the recorded copy of the encounter in the following months and the following weeks, and that we'll discuss probably also within the framework of the different masters in different universities, the topics you have brought on the table today. So take care. Join us, please, for the next encounter, which will be the 37th, and which take place in November 2024, and where be for sure that we will discuss, as usual, new avenues for intellectual property in the 21st century. So as always do, we will prepare materials for you, we will prepare references, we will provide splendid speakers like today. So thank you for being with us. Enjoy the rest of the day, wherever you are all around the world, and greetings to you and greetings to your families. Bye-bye. Bye-bye, Gabriele. Bye-bye, Peter. Bye-bye, Andrea. Laurent, Javier. Have a nice afternoon, morning, evening, wherever you are. Thank you.
Thank you. Thank you.